This is the Financially Simple Podcast, the show dedicated to destroying the complexities of money for today's small business owner. The content in the show is for informational purposes only. This show is not investment advice. Instead, seek help from a competent financial advisor or conduct your own due diligence. Justin Goodbread, CFP, is an investment advisor representative of Heritage Investors, a registered investment advisor only conducting business in states where it is properly registered or is excluded or exempted from registration requirements. Registration is not an endorsement of the firm by securities regulators and does not mean the advisor has achieved a specific level of skill or ability. Here's your host, pizza-loving, certified financial planner, Justin Goodbread.
And welcome back to the Financially Simple Podcast. I'm your host, Justin Goodbread, and today we're going to change gears a little bit. We spent the last few episodes in our series looking at risk management, and we talked about insurances. Every type of insurance is out there. We talked about life insurance. We talked about disability. And we even talked about the dreaded health insurance. As you can probably tell from my voice, it's not my favorite topic. I don't like health insurance. I think it's a waste of money, but that's another day for another topic, yada, yada, yada. Anyways, we're in our second season now of the podcast, and for some now 30, 40 episodes, we've been dealing with personal finances for business owners. Today, I want to talk about a foundational document in risk management, and we're shifting away from insurances, and now we're going to start speaking about legal documents. I had the ability to bring an attorney on, many attorneys. I know dozens of razor-sharp attorneys that we could bring onto the show. But I wanted to not do that. I didn't want to have lawyers speak. And I know some good ones who don't talk like lawyers. Instead, I want to talk to you as myself, as a certified financial planner, as a certified exit planning advisor, and as a certified value growth advisor. I have dealt with this conversation that we're going to have today dozens, if not hundreds of times over my career. You see, whenever we bring a new client on, whether it is to help them grow their business, whether it's to double their net worth, which I try to do every 3 to 5 years. It's my personal goal for every client is to double the net worth every 3 to 5 years. Whether it's to help with a tax team, reducing their taxes, get their budgets in order, whatever the scenario is that we're trying to do for the client. Inevitably, we end up dealing with the risk management level of personal planning. And so many people either have no will at all, which is sad to me, and we're going to see why today, or they have an outdated one that's 20 years old, 30 years old. I've had family members who I had to coax and beg and plead to get their wills done. So today I want to cover this basic document. What is a last will and testament? I want to cover the key points of a last will and testament. So this is going to be my financially simple terms. As I mentioned earlier, I'm not an attorney. You know that. If we ended up working together, if you say, hey, Justin, I want to hire you to help my company grow. I want to hire your firm and your colleagues to help double my net worth every 3 to 5 years. If that's the goal that we're trying to achieve, I'd like to hire you to do that. I would say, great, let's get a razor sharp attorney in to help work in this particular area. And we would hire a good attorney to help us with these estate planning documents. Today, I want to just cover some basic concepts. This is not legal advice. It's not even financial advice. It's just educational purposes for today. So let's deal with this. What is a will? In my simplest terms, as I was crafting a definition, and this probably is a better definition out there, but this is my financially simple terms. I would say a last will and testament is a legal document that's going to communicate or tell other people your final wishes as it relates to your possessions and your dependents. So let me break that down. It's a legal document, meaning it's binding. It's enforceable in court. It's going to communicate once you're gone. It's going to tell somebody your wishes, what you want done with your possessions, those things you own here on this earth, and those dependents, whether they're minor children, special needs, elderly parents, or somebody you've been entrusted with for their care, the dependents. Who are you going to leave the dependents to? It provides details on where your possessions go and who cares for your dependents. That's the simplest way I can get it. Now, whenever we start examining that definition, we want to first look at possessions. We're going to make the assumption that many, many, many possessions are governed. The technical term is they pass under a will. They move from one party to the next under a will. Except, and there are many assets which the will does not govern, does not allow control. So I wrote down a couple of them here. This is not an exhaustive list. This is where your attorney is going to look at your specific financial situation and tell you this is what's going to pass, this is what's not going to pass. But here's some that I commonly see. So if you have an asset that is a joint tenants with rights or survivorship, we call it JTROS, JTROWROS. So joint tenants with rights or survivorship. If you own an asset like that, the will's not going to control it. So let's say me and Ms. Emily, we own our house, joint tenants with rights or survivorship. If something happens to me, she automatically gets the house. We have our bank account set with rights of survivorship. Something happens to me, the money goes to her without the will governing that in any way. You may also have a co-ownership position. That may or may not be governed by the will, depending on the state. And we're going to talk about that in a second. Another thing that most people aren't aware of, or many business owners aren't aware of, is that life insurance proceeds are not governed by the will. They're not. There's a beneficiary status on the life insurance policy. Therefore, let's keep it in my world. Something happened to me today. My life insurance policy lists the proper beneficiaries. And that could either be spouse, friends, family, trust, whatever, charity, who knows. The life insurance proceeds are not governed by your last will and testament. Your pension plans, like your retirement plans, your IRAs, things that have beneficiary status on it. So if you have a 401k, a pension plan, an IRA, a Roth IRA, a CEPA IRA, a solo 401k, anywhere that you write a designated beneficiary on, it is not controlled. It does not pass under the will. The account's type itself denotes who the money goes to. Another one are informal type of trust accounts, informal trust accounts. The technical term is what's called a Totten trust, but you may recognize what's called a payable upon death account. Payable upon death. So it's not uncommon for, especially whenever an older generation is being cared for by a younger generation, for the younger generation to have a payable upon death listed on the bank account. So grandma, grandpa may list mom and dad, or may list you as the beneficiary of a bank account or a CD that is not in an IRA. And whenever they pass, it automatically gets transferred to the beneficiary on that account. That's called a POD, a POD or POD account. Another type is what's called a TOD account, or a transfer upon death account. Now, that's not a Totten trust. Instead, this is the actual bank accounts, the savings, checking, CDs, investment accounts. They actually transfer upon death to a beneficiary. So a POD account is what's called a Totten trust. It's a special informal trust. And a TOD is a bank account or the like. In layman's terms, folks, they basically work the same way, POD, TOD. They're just controlling different assets, and they move the money from whoever the grantor, the person who's alive, they move it from that individual to the beneficiary, and it doesn't go underneath the will. Now, there's a legal term called inter vivos. And basically, it's gifts that you made. Any gifts that you make to others during your lifetime does not go underneath the will. Other things are trust, certain types of trust. So, for example, if you place money into a living trust, it's not going to move underneath your will. If you place money into an irrevocable trust, or the various trusts that we're going to get into here in the next few episodes, then those assets that are owned by that trust or placed in a living trust, etc., do not pass under the will. The trust document dictates where they go. If you're in a business partnership, you have the ability to transfer your interest in the partnership via the will, or maybe your partnership agreement. Your partnership agreement can sometimes supersede the will document, the will itself. If you own personal property that you've given away to others, that you left them, that really has no value, little or no value, small things, typically the will doesn't have to outline those type of things. For example, I recently had many family members pass away, and they left this little trinkets like antiques, nothing of any significant value. It didn't have to go underneath the will. The executor could just move it to us. As I mentioned in part number 1 on this, what doesn't pass underneath the will? If you happen to live in a community property state, and there's several, I'm going to name a few. You got Arizona, California, Idaho, Louisiana, Nevada, New Mexico, and there's many more. I think Texas, Washington, maybe even Wisconsin. You'd have to talk to your particular attorney to see if you're in a community property state. But if you live in a community property state, generally all the property that you and your spouse acquire during the marriage is considered equally owned. And so it basically leaves your half of the property to your spouse. So this is where your attorney is going to help you determine what type of state you're in. But a community property state, some things that are not controlled by the will in that state. So there's a lot of things that are not controlled. Now let's get one thing clear. Who you leave your dependents to is crystal clear, controlled by the will. Crystal clear. There's no exceptions, folks. Well, I would say there's probably some clever way to do it, but so that leads to the question, what happens if you die without a will? Okay, Justin, I get the fact that I need to leave assets to somebody, and the will's going to tell them who to go. But man, screw it. I don't want to leave any assets to anybody. I just want to die, and whatever happens, happens. Well, let's talk about what actually happens. If you die without a will, you're dying what's called intestate or intestate, depending on how you hear people pronounce it. It basically means the state becomes your executor. They're the ones, and we're going to talk about these keywords, but they're the ones who become the executor. And to settle the estate, the state then decides how they're going to distribute your assets. So, well, doesn't sound too bad. Then I don't have to deal with all my family squabbling when I'm gone. Correct. They're also going to establish guardianship agreements to try to determine who is the best person to care for your children. Friends, as a dad, I have a hard time seeing where any father, forget a mother. I mean, we all know the mothering instincts that God gave all of our mothers, and we're grateful for a mother. I'm super grateful for my mother. I'm talking about just as a dad, because that's all I can experience. It's a cold day in hell, friends, before I let the state of Tennessee decide where my kids are going to go. We've all seen the show National Lampoon Vacation, I'm sure, with Chevy Chase played a great act inside there. Well, we have Cousin Eddie. Cousin Eddie. Never forget the part in the show where he has his RV out on the side and he's dumping his RV sewage into the drain tile. Just Cousin Eddie. The state could very well determine that those children whom you have coddled and taken care of, or that special needs child that you have labored so much on, the state could decide that the Cousin Eddie of your family is going to be the ones responsible to raise your children or to raise those whom you've been entrusted for as guardianship over. That is sick. So let's just stop right there. If you don't have a will today, and you say, well, Justin, I'm not going to die. Man, I wish I knew that for a fact. We're not guaranteed tomorrow, friends. We're not even guaranteed today's breath. The very breath that you just took, that breath that you just took is a gift from God Almighty, and we ought to be grateful for that very gift. We're not guaranteed tomorrow. Think about it. I've got a client who's dying right now. Just retired. Dying. No, it's the last thing in his mind. My dad, I didn't expect my dad to fall over dead. I just hugged him after a hurricane, drove back up to Knoxville, Tennessee. The next day, he's gone. We're not guaranteed tomorrow. If you don't have a will, get off your butt, contact an attorney, and get a will done, especially if you have kids. Okay, I'm off my soapbox. You're like, dude, Justin, chill out. Yeah, well, this is serious stuff, friends, especially when you realize the sheer number of people who don't have wills. And if you're one of those, shame on you. Shame on you, especially if you have minor kids. Be a man. Be a woman. Grow up. Take some responsibility. Okay, I'm done now. I promise I'm off the soapbox.
You're listening to the Financially Simple Podcast. Show your support by subscribing to this and our other educational business channels at financiallysimple.com.
So let's deal with what happens in a will, the key factors of a will. There are basically 4 key factors to a will. Now, an attorney who's going to draft this for you, they're going to go through all the ins and outs. I'm going to stay super high level today and keep it in layman's terms. Your particular state is going to have different governing rules, and the attorney is going to be able to craft that will in such a way that it meets your wishes. In next episode, I'm going to talk about some things that I've seen as it relates to legal documents that help. I'm even going to talk about the way that I designed my will. And it may help you. It seems to help people, especially in their 40s and 50s. We'll give some examples of folks in their 60s and 70s as well, because I know we have quite a few listeners. It surprises me how many 70-year-olds we have listening to the show. So here's the 4 major factors to a will. They're all people. We already know what assets don't pass under the will. And we also know the dependents we have. That's a given. We live in that situation every day. But when it comes to drafting a will, you're going to have to know 4 different players. And each of these players have a special role. Now, I'm going to tell you that each of these players, when you name somebody, you should go 3 deep. And I'm going to explain that here in a second. So let's deal with these players. The first player is what's called the executor or executrix. That's a male-female name. Basically, the executor or the executrix is the person who is responsible for carrying out your wishes, for reading the actual legal document and determining what you want. Now, the court, what's called a probate court, is going to oversee the activities typically of the executor or executrix. So whenever I say 3 deep, I want you to think of this. You say, well, Justin, I really want to name my spouse as the executor. So right now, Miss Emily is my current executrix. If something happens to me, she's the person who's going to handle moving the assets that pass underneath the will to the right people. But what happens if me and Miss Emily are driving on a hot date night one night, and lo and behold, a log truck, because I like to pick on loggers because I have my brother-in-law's one, I like to give him a hard time. Lo and behold, a log truck comes out of nowhere and sideswipes me, and Emily and I are gone, and we see Jesus, and now she's not there. Well, then I may name my brother, or my mother, or my father-in-law, or a friend, or an uncle, or an attorney, or a CPA, or a CFP. I may name somebody to be the second person there. So I would have Emily as my number one. Emily and I got hit by a log truck, and now let's just for kicks and giggles, because I love to kill my brother off. Let's say my brother's riding with us, and he's my number two. What happens then? Well, you need to have three deep. You need to have three different names that you name to be the executor or the executrix. We're going to talk about next time why you don't use and why you just want to name one name there. I've seen some nightmare stories there. But we want to deal with the executor. You want to name a name that's the person who's going to be responsible for carrying out the wishes. And you want to have three different people named in that situation. Now, the next is, who are the beneficiaries? You said, Justin, that's easy. I'm broke. I don't have any. Yeah, I understand that. I've been there. You say, well, Justin, man, I've got a ton of money. What am I going to do with this? Yeah, I'm there often with many clients. I can't say I have a ton of money, but been blessed. We actually have one of our dearest clients that we've loved for years, over 15 years. And we're in the middle of this wrestling with this. What do we do with the money? They have amassed a significant amount of wealth. So much so they'll never be able to spend it, and they live an extravagant lifestyle, and they'll never be able to spend the money. What do they do with it? Well, they have children. Yeah, but their kids are now in their 50s and 60s, and they're okay. Well, they have grandkids. Well, but if you give the money to the grandkids, does it spoil the grandkids? Does it make them where they're entitled? We got to deal with that. So we're going to talk about that next episode. How do you determine how to break up beneficiaries? But in the beneficiary status, you want to list who gets the money and what percentage you'll get. If you have a specific thing that you want to leave to somebody, you write it in the will. I had one client, a dear lady. We worked together for probably 5 years. Love the family. In fact, I still work with the trustee of the family as a client. She owned some farmland. She owned a lot of fun stuff. I remember this one table in this family, and this table was what she raised her 7 children around, and the kids would carve into the table. She had to determine who got the table. There's so many memories carved into this table. Ultimately, she decided they were going to saw the table up and give a piece of the table to each of the children and to the grandchildren. And that's what was done, I believe. Can't quote for a fact, but I believe that was her wishes. I remember seeing that in the document. So you have to determine who's going to get the proceeds. And by the way, it doesn't have to be your family. You can name a friend. We've heard of those before. You can name a charity. You can name a college. You can name a church. You can name a foundation. You can place the money into, I've actually seen where people put in their pet's name. That creates a little bit of problem, but I've seen that happen. You can leave the money anywhere you want. Who's going to get the money? Not only the money, but who's going to keep your kids? Now, we already know we don't want the state deciding. I've already told you what I feel like. It's going to be a cold day in hell before I let the state decide who gets my kids, because I believe it's God-given responsibility for a daddy and a mama to make that determination. And again, shame on you if you've never done this and you have small children. Who are you going to leave your kids to? That question is one of the single reasons why wills are often not done, because families can't decide who are they going to leave their kids to. I mean, we live in a family, right? All of us are different. My brother and I are so different. It's not even funny. My sister and I are so different. My mother, my father-in-law, we're all just different. And we can nitpick. And so many times I see people nitpicking about who they want to leave their kids to. They even look at friends and like, well, I don't like their belief on this, or I don't like their values in this area. You need to decide on somebody, or else Cousin Eddie's going to be the guardian. And not only that one person, but you want to decide on 3 people deep. What happens if you leave it to your best friend? And like one of my best friends and I just went out of town with our wives. We were all in the car together, and all of a sudden that log truck comes rolling down the hill and hits us all. And my best friend and his wife is, let's say, potentially who we wanted to leave our kids to be the guardians. Who's next? So you're going to name 3 people deep to be the guardian. And the 4th player in this will is the trustee. So the reason why I bring a trustee into play is because with someone with minor kids like myself, or many of you have minor kids, if you have any size of assets, you're not going to leave those to a 3-year-old. It's going to go in trust. So right now I have a significant amount of life insurance on me because of the business that I operate and the family that I have. If something were to happen to me, that significant amount of life insurance would go to my wife. But let's say me and Miss Emily were riding in the car, here comes that log truck, and we're gone. Those life insurance proceeds will now go into a trust per the will. My attorney drafted that for me. It goes into a trust per the will. Once it's in the trust per the will, there is a trustee who manages those proceeds for the benefit of the beneficiaries. In this case, it's my children and a charity. The trustee is the person who makes sure the money is distributed, is cared for, it grows, it's invested, it's distributed whenever the kids or the charity needs it. The trustee is the person. So you have 4 players to decide on, 4 people. And on 3 of those, you want them to have 3 different selections. Your first, your second, and your third selection. And those 3 were the executor or the executrix, the guardian, the person who's going to take care of your small children, and the trustee, the person who's going to manage the money for your small children. Your beneficiaries are whoever your beneficiaries are. But you have 4 major players to determine. Friends, that is as basic as I can give you last will and testaments. That's as basic as I can get it. Now, next episode, we're going to talk about some of the different nuances, some of the different things I've seen on how you deal with some of these life challenging situations. I've heard lots of wise attorneys give different counsels. I'm going to try to bring in multiple different viewpoints, notes I've taken over the last 18 years from various attorneys at various stages of life, and try to give you some different perspectives on some things you may consider as you now go out and get your will or renew your will. And with that, friends, I want to tell you to check out the Financially Simple blog. It is rocking. The team is getting ready to do a full facelift on it right now to break out some university work we're going to be doing. They're also now running some different information points on our social media. So if you like Facebook or Twitter, LinkedIn, whatever, I think we're on Instagram and maybe even Pinterest at this point. Check it out. There's a lot of interesting information there the team is pushing out to try to add additional content for you. Hey, I say it every week, friends. Life is hard. It is. Life is hard. Decisions on a will, man, they're tough. Life is good, though. Life is good. Life can be frustrating. Money in this legal state, it doesn't have to be. Let's continue to make our lives at least financially simple. Hey, y'all go out and make it a great day.
You've been listening to the Financially Simple podcast. For more business and personal financial help and information, head over to financiallysimple.com today.